Good morning. You ready to go? Folks online? Okay, good morning. Welcome to everyone here in person and those joining us with a Zoom link today. Today is the third in our series on race, realities, and responses in South Carolina and the United Methodist Church. The series is sponsored by the Church and Society Committee of Shandon. Let us begin with prayer. God, who spans our differences, help us to listen with open minds and hearts and see with new eyes. Help each of us to understand how to step forward in faith and to build bridges across barriers that divide people. Grant us safe crossing and bring us to a new home. Amen. As Christians, we're called not to stay neutral when there are hurtful and racist policies and attitudes going on. So the purpose of this series is to motivate each of us to shine a light on racial realities and how activist people of faith are responding. Each of these 4 Sundays, we are having guest leaders speak to us who bring their own expertise from various directions. Today, we're honored to have Lynn Teague with us. And if anybody wants to question her credentials in terms of being able to speak to citizenship in South Carolina, she goes back 12 generations in South Carolina. And among her progenitors were some of the first people to rise to elected office. Nevertheless, she's an archaeologist by trade and by training and so forth. And so she'll be helping us to dig up some of the past, whether we are proud of it or not, and to discover the new ways in which we might make life in South Carolina and citizenship a reality in our lives. Lynn?
Thank you very much. Yes, this is obviously a subject near and dear to my heart because I spent an awful lot of time in my retirement working on it. My husband accuses me of having failed retirement, but I'm very happy with what I'm doing. Can everybody hear? All right, yeah, okay. Racial Realities and Responses is a great name for this series. Voting rights and elections have become immensely contentious in our country and in our state, with a great deal of partisan mudslinging. So what are the realities? A focus on issues rather than personalities, party allegiances, and verbal napalm helps us avoid becoming wrapped up in false claims and therefore unable to make genuinely useful changes. I work on voting rights and elections at the State House, among other things, on behalf of the League of Women Voters. We are a nonpartisan group dedicated to education and advocacy on fundamental issues in our democracy. We don't support any candidates or parties. I work regularly with legislators of both parties to pass good bills, amend bills to make them better, and try to stop bad bills. Before I move on, I'm going to encourage you all to visit our website because I'm not going to recite a bunch of bill numbers at you this morning. So if you want more detailed information, we have it online. Go to www.lwvsc.org under advocacy, and you'll see a list of the bills that have been filed so far that have to do with elections and voting and other issues that we're tracking, along with our testimony on those that have already had subcommittee hearings. The League's nonpartisan approach is a great fit for me personally. My perspective doesn't come from a political party, but from my life. I was born in 1948, and that was the Jim Crow South of my childhood. I recall vividly playing in my grandparents' backyard in Vance, watching Black children my age, walking back from working in the cotton fields, exhausted and dirty. I realized their lives were going to be very different than mine. Even a child could see that something was very wrong. I didn't learn that from a political party. I learned that the values that made that clear from my family and from the Methodist Church. There wasn't a lot of preaching about social justice issues in the 50s when I was a small child, but there was a lot of preaching about the gospel. And you couldn't put these things together and see, you had to see that there was a bad mismatch between the love we were supposed to have for our neighbors and what was happening. So issues around voting come down to who can vote, how can they vote, and does it mean anything when they vote? All of that has changed over the years. However, there are common themes. Politics have always been to some extent about numbers and about which people are recognized as full participants in society, about who is considered worthy of a voice in public affairs. In our society, the right to vote is a fundamental recognition of a group of people as capable of and entitled to participation in decision-making on public matters. It has always been true that this recognition comes most easily when the people already in power recognize others as like themselves, not fundamentally different. When South Carolina was first settled in 1670, only land-owning white males who belonged to the Church of England could vote. Early in the history, they prevented French Huguenots from voting. They didn't share the same values, alas. They changed that. Eventually, the barrier of land ownership dropped so that all white males could vote. It took the Civil War and the subsequent 14th and 15th Amendments to the US Constitution to give Black men the vote, if only in theory. After Reconstruction, it was not in practice. Women of any race were permitted to vote only in 1920. There was a lot of public opposition because it was said that would just be redundant because of course women would simply vote like their husbands. And this tells us a lot about what those politicians thought of women. When I was in high school in '64, that was the Freedom Summer, when there was a concerted campaign to register Black voters who had been denied the right to vote since Reconstruction. The same time I was hearing at University High School that the civic responsibility was to vote, other people were being beaten over the head and sometimes murdered for attempting to. We all know that it took federal enforcement of the Voting Rights Act of 1965 to ensure that Black voters could vote throughout our nation. And to this day, we still hear about states' rights when people think it would be nice not to have so many people voting. Many of us believe this was behind us. However, problems with deep historical roots don't disappear overnight, or even in a decade, or even in half a century. And listening to the remarks of some legislators at the State House, I've realized that some of them genuinely think their concerns rise from principle when racial blinders are actually at work. They complain that they don't want Sunday voters because ministers will tell people how to vote. And then they effusively welcome clergy and members of several faiths to their hearings when they're on the same side on the issues. They speak with distaste of cars that pull up to polling places multiple times during a day, bringing voters, as if there's something obviously objectionable about helping people without transportation get to their polling place. We need to be alert to deep-seated bias affecting the dialogue about voting. So, what are the realities of our legal situation in South Carolina today? The two essential components of good elections are security and access. We need both of them. We need election integrity, but we also need access. We need reasonable access for all qualified electors. In South Carolina, the League of Women Voters has been very close to this issue for a very long time. We meet regularly with staff of the State Election Commission. We are very familiar with the laws. We've helped shape the laws in some cases. One of our members is now on the Election Commission. And so I can tell you that while our elections are not perfect, they're an awful lot more secure than many people think they are. There are reasonable measures that can and should be taken to increase public confidence in election integrity, but they should not be allowed to compromise the access of all of our voters. We don't improve election security by making it harder for people to vote. So As it happens, a lot of the people for whom it is less convenient are Black or Hispanic, very often rural, very often low income. And some of this is accidental and some of it isn't. Sharing power is painful for many people. Equal access to the ballot means an election system designed to work well for everyone, including those who have trouble getting off work or missing hours of work and pay, those who lack transportation, those who lack access to broadband, many things. I hope to lay out for you some of the evidence-based realities about elections in South Carolina in a way that will help you decide how you want to respond and participate. We can have both security and accessibility if we're willing. South Carolina has a 2-year legislative cycle. We are now between the 2 years of one of those cycles. In 2021, we've seen many new bills introduced that would change elections in South Carolina. More will be filed when legislators return for the 2022 session. Actually, they pre-file about a month, more than a month before they come back, but then they keep filing during the year. Some of those bills are sound and well-intentioned, but others appear to be efforts to limit the access of racial minorities to the polls. Furthermore, some with good intentions would still not work to the advantage of equal access to the vote. It takes a lot of in-depth knowledge of elections and how they work to understand this. I recently sat through a 6-hour hearing that was occasioned by people who were convinced that South Carolina's elections were totally fraudulent. Their evidence was that, and I quote, Lindsey Graham was elected and no true conservative would vote for him. And some other things that I'll be discussing. But anyway, you have to understand how it works to understand how it can be better and how it's needed to be better. So I'm working with legislators in both parties to try to amend some of the bills that have been passed. In one case, a very young and very well-intentioned Republican legislator proposed a bill that would give us early voting, no excuse early voting. We have absentee voting if you have an excuse. This would be 10 days of no excuse absentee, but he put in polling requirements that would have severely disadvantaged minority voters, both those in rural low-density areas and those in high-density urban areas. I ran the numbers and gave testimony against those provisions. Attorneys from the national attorneys from the NAACP LDF, Legal Defense Fund, who are great, by the way, also testified. And the young man was totally astonished. He hadn't figured this out himself. I mean, he simply didn't understand how it worked that well. When I spoke to him afterwards, he said he was more than happy to talk about amending the bill because he didn't want to be featured on Dateline. So I'm glad he has good intentions, but we need more than good intentions. We need in-depth knowledge. So a lot of attempts to make voting more restrictive are based on the accusation that there's voter fraud. There are occasional single voter instances of fraud, but anything more ambitious is very, very difficult. And I'm going to explain to you why so you can understand why these arguments are so poor. We recently, that 6-hour hearing was in part, again, accusations of dead people voting. It's the great zombie voter issue. When I first started working for the league at the State House as a volunteer lobbyist, the zombie voter issue had come up in 2012. And what happens is people look at the list and they don't have the resources to really check the list, and they don't understand how it works, and they conclude that we've got a bunch of dead people voting. We do not have a bunch of dead people voting. And I will explain how we can be very sure of that, other than the fact that every list anybody's ever come up with has been checked, in some cases by SLED. SLED produced a 500-page report on the 2012 allegations, and we're unable to find a single instance of voter fraud. SEC has already checked the more recent charges of 2,000 dead people on the registration list and about 10 actually voting. Again, not true. It's unfortunate. They wasted a whole lot of their own time, and then they wasted a lot of my time, but in any case, let me explain that registration rolls are always going to have people on them that shouldn't be there voting, either because they're dead or they've moved, because you can't keep completely current registration rolls. You know, you're not going to convince doctors that when they declare time of death, the next thing they should do is get on the phone and call the election commission. So there always going to be a lag, but there are a lot of safeguards in place. If you think through the voting process, first of all, how is somebody going to vote in person? You have to have ID. So you show, you know, they're not going to vote in person on behalf of a dead person. They'd have to vote absentee. Well, to vote absentee to get a ballot, if any of you have been doing this, you know that you need the last 4 digits of the social security number and a date of birth. Usually that's only an immediate family member who's got that kind of information. In 2020, nationally, there were 2 documented cases of this happening, including a gentleman who murdered his wife and then voted in her name. Okay, but the State Election Commission really has a lot of resources. They get, DHEC gets Social Security information on who's dead. And if anybody's ever handled an estate from a close family member, as I have, you know, Social Security finds out fast when somebody's dead. And because they don't want to pay out money, they don't have to. DHEC passes that information on immediately to the State Election Commission. That is fully adequate to purge a list of people who are deceased because you have the Social Security number and the date of birth. So even if that hasn't happened by the time somebody gets an absentee ballot, it's probably going to happen by the time the ballot is received back at the county election office. At that point, they look at the rolls, they see the voters deceased, they throw out the whole envelope. End of that ballot. If they squeeze through that little tiny interval, you know, between the time that they you know, that they haven't gotten the notice and the ballot is counted because someone dies right before election day, it's still going to get caught because the election commission checks who voted in each election. They record on your voter record whether you voted or not. If they look at it and it says you were dead before election day and you still voted, they would catch you anyway, and they'd catch you. You know, they'd know who to look for because, again, it's not that easy to do. Dead people voting is simply not something that can be used as a systematic fraud scheme. The other thing that people get really excited about is people who've moved, you know, are people registered in 2 states. And a lot of people are registered in 2 states. Very few people think to notify the election commission of the state they leave, that they're leaving. State Election Commission knows this. They are on a number of databases, including the Postal Service's national database that records changes of address. They also have access to a separate database that was established by the Pew Foundation, but is now run by the states, in which states exchange the information needed to make an accurate determination of who has moved. Overall, the voter registration rolls are simply not a significant problem for voter fraud. And so when you see claims that we should have draconian purges of the voter rolls, that we really need to kick more people off more vigorously, no, we don't. That's simply going to disenfranchise people who are legitimate electors. Okay, so the voting registration is not a huge issue that it's made out to be. What about voting access in the voting process? And there are 2 problems that can happen there: voting denial and voting dilution. Denial happens when you actually prevent someone from voting in practical terms, even if it might theoretically be possible. Voting dilution relates to redistricting, which I'll mention later. South Carolina already has very conservative voting laws. They have not kept up with the fact that our electors are not the same people who set up the rules in the first place. Low-income workers can't stand in line for hours because the machines are down without losing wages they can't afford to lose. People in rural areas have problems often getting to polling places. Having voting on one day is simply a pretty archaic process and not at all necessary anymore. But given our conservative voting laws, it's sort of a good news, bad news joke. The good news is we don't have to worry about some of the bad voting bills that we're hearing about from other states, taking away access provisions because we don't have them in the first place. We don't have drop boxes and so forth to make it more convenient. Yet we hear, how can you trust the security of a drop box? We have excused absentee voting. We've had it for years by mail. People put it in a drop box. It's labeled by the USPS. That's a secure drop box. Okay, so if the Election Commission were to establish additional secure drop boxes, it really is something that is simply making it easier for people to vote. We see, however, in our neighboring county of Georgia that they just passed a law that would leave it at one drop box for 200,000 voters in part of Atlanta. But here we don't have them at all anymore, unless it's somebody standing by it at the election office, so you can drive up and hand in your ballot to someone who puts it in the box. Making progress on this is very hard. We believe that you should prove that there's a realistic danger in a fraud in refusing to make some of these good changes that we need. However, the Supreme Court just took a very different position here some weeks ago when they weakened Section 2 of the Voting Rights Act, having already destroyed Section 5, but they weakened Section 2 by dictating that if there is an alternative means of voting that somebody in theory could get to, access measures can be restricted. In essence, they ruled that we can return to voting practices when the Voting Rights Act was amended in 1982. Well, a whole lot of really good changes have been made in many states since then, things we need, some of them things we have, like online voter registration. But what the Supreme Court is saying is they're not going to protect those things. So we also see concerns about security and proposals to limit access because of claims of fraudulent absentee mail-in ballots. You can't really do that very easily. I know there have been people looking at ballots to see if there are bamboo fibers in them at great expense to the state of Arizona, where I've lived for 30 years. But the way absentee ballots are handled makes that impossible. Absentee ballots are numerically coded to link them to the registered voter who requested them, and they're issued only to those who have the voter's date of birth and social security number. When an absentee ballot is received, the number on the ballot must match the name on the voter rolls to whom that number was issued. Okay, you can't just throw in a bunch of randomly numbered ballots and expect it to be counted. There must not be the check to make sure there's no record of the voter already having voted, for instance, absentee in person. The ballot is checked to see if the voter is recorded as having died or moved since the ballot was issued. And if the ballot passes those steps, the voter is recorded as having voted, so they cannot successfully go in on election day and vote again or vote in person early. So there are a lot of protections there. One thing we frequently see are attempts to restrict our existing excused absentee provisions. That's one of the things this naive young man was proposing. And it's often by people who don't understand exactly who's going to be hurt if they do away with some of our excused absentee provisions that we already have. They claim cutting down on mail balloting is necessary to prevent fraud. I think I've laid out the reasons we don't believe that's true. Mail balloting is secure, but they try to argue, well, if we have these provisions, we don't need to allow caretakers for people with disabilities to vote absentee excused, or we can raise the age to 75 or whatever. Generally speaking, as soon as they hear from their voters, they back off from those, but it is a continuing effort to make it harder to vote excused absentee in South Carolina. All right, there's often a charge of ballot harvesting, and that is behind one of the bills that's in the Senate. And this is a sort of a derogatory way to refer to someone, a group of people collecting absentee ballots from others to deliver to the election office. Now, it can be a problem. For example, in 2016, a party operative in North Carolina did this. Although he also got caught and went to prison, it's a felony. He picked up people's ballots and disposed of the ones that he wanted to dispose of. There are no documented cases of a problem of this kind in South Carolina. However, I'm working and the league is working with legislators of both parties to reassure people about this. The first proposal that came before the Senate subcommittee was that only immediate family members would be allowed to turn in somebody's absentee ballot in person. This is especially an issue now that mail-in voting is harder. But we have argued successfully that that would be really a terrible burden on many people who don't trust the mails to get their ballot in on time, and who, for instance, rely on a next door neighbor, a shut-in who relies on a next door neighbor, a nursing home resident who relies on a staff member. So we're working to change that to simply, for instance, limit the number of ballots that one individual can deliver on behalf of other people, but not do it in such a way that people will be unable to vote. Okay, voting systems, is that a problem? And what are we going to see happening in terms of bills that relate to this? And actually, that's already sort of, the big decision was already made. And as you just doubtless discovered in the last election, we have new systems, express votes. I will tell you, the league is not crazy about them. You will be told that in some cases that these computerized voting systems are vulnerable to problems, and they are. It's not a matter, however, as many people think, of just hacking into that ballot marking device. However, we don't have enough controls on who programs the machines that people use to mark their ballots. We don't even know who owns the companies. There are only a few companies. Express Vote is made by ES&S, that's our system, Dominion, and there's basically only 2 or 3 other very minor competitors in this whole business. It isn't well regulated. But basically you need to work for the voting system company if you're going to do too much damage that way. So what we would like to see is more control, more information, more transparency about who owns the companies, who's running them, and who's handling the ballots, ballot programming. But there is a way to deal with this, and we are going to encourage legislators to do this, to take a measure that would take care of that, which is risk limiting audits, to do statistical audits by hand of the printed ballot, not run it back through the machine, which has been South Carolina's way of auditing, but in fact, to have someone take a sample, not all of them. We don't want to do what Maricopa County, Arizona is doing, but take a sample and have somebody actually read the printed words, the names that were selected on the ballots, and make sure that matches the machine total. Because the machines don't read what you read. The machines read a barcode. That's basically why the league doesn't like them. Because you can't really verify, you're not reading the same thing that the machine is reading. But risk limiting audits are a way to deal with that. So we want to see bills introduced that will introduce risk limiting audits so that we can reassure voters that everything is working the way it should. Because anybody who's ever worked with a computer knows that even with the best of intentions, they have glitches. And we have had a computer science professor at USC who's audited every general election in South Carolina since 2010, and there have always been glitches. None of them would have altered the results of an election, but there always are computer glitches, and especially when you have people dealing with these machines who don't normally get to them. Every 2 years they work with them. And the verified voting group, and that is their URL online, www.verifiedvoting.org. If you want to see more about how that sort of thing can be handled, they are nonpartisan technical experts on election So election accessibility is simply still very uneven. And it can be made even more uneven by things like uneven distribution of numbers of machines, uneven allocation of voters to voting places, and so forth. And in fact, registration is unevenly available because a lot of our state lacks broadband access. We are lucky in that we have online voter registration, but some people can't use that. But it is possible to distribute polling places in ways that make people without public transportation unable to get to their polling place. It's possible to do a number of very unpleasant things simply by the way you administer the system. And so it matters a lot who runs the system. South Carolina, interestingly, does have a nonpartisan, independent voting commission. And as far as I know, I think there's one other state that has something similar, but most states, the election people report to a partisan elected Secretary of State. We don't do that. You know, it's always a surprise when you find out South Carolina's ahead of the game on something like that, but here we are. And there are 5 commissioners. And there is, of course, always the issue of backroom pressure on commissioners for how they decide things. The league strongly suspects that has actually happened. But we're still ahead of the game in having that commission. We need to keep them independent. We don't want to put them under the Secretary of State. And there, of course, there's always a bill to do that. There's always an attempt to move the election process into a more partisan framework. As an alternative to that, and as an alternative to attempting to take over the county offices, which at this point can adjust their polling places to suit their local conditions very well. In the Senate, there is a bill that has been sent over to the House that would give the Senate advice and consent on appointment of the commissioners. And that was an attempt to head off more extreme measures. And I will say that in 10 years at the State House, I have never seen happen what happened to that bill. It was sent across the lobby on sine die, which is the last day of the regular session. And at that point, the normal process is that the House says, okay, we've received our bill back amended. Do we accept the amendment? Vote yes or no. If we vote no, then we appoint a conference committee that will resolve the differences between the Senate's amended version and our version. Instead, they acted like they've never seen it. A whole lot of us who were cumulatively in the State House for probably 50 years were standing there going, what on earth did they just do? They actually just disappeared a bill. Now they've reappeared it acting as if it came too late to act on, but it didn't. We saw it go across. And so we'll see what happens with that one. The House would like to take over the county offices with plenary authority. Now, the state election office already has the authority to make county offices obey state and federal election law. Plenary authority would mean that somebody in the State House could say, you can't put more polling places there. You can't give that many machines to that neighborhood. You know, you could do a lot of things that would be very repressive. We don't need that happening. County people are closer to their population and their citizens, and we believe that while there are occasional problems, we have been able to deal with them, and we don't want to see this happen. So we would support the Senate advice and consent over the notion of giving the state plenary authority. So what are our realities and our responses? Okay, our voter registration rolls are not a problem. The SEC, the State Election Commission, is currently following all the requirements of federal law as well as best practices recognized in the profession of election security. They're looking into improving this by getting death data directly from Social Security rather than DHEC. This is a response to the 6-hour hearing. It might allow them to get data 2 or 3 days earlier on who has died. But that's about all you can do to make that zippier, but fine, good. I mean, if you can do it, good. We need those risk limiting audits to reassure voters that the totals generated by the computerized voting system match what voters intended. We should consider additional measures, such as requiring ownership disclosures for voting systems. And we are willing to look at the number of absentee ballots that a person can turn in. We would like to see the voter registration deadline extended closer to election day. That would help people who move close to election day get registered in their new location. It would help. All the things that make voting easier tend to be especially good for low-income people, very rural people, and often minority people. We want to see expanded broadband to help register more voters, since by far the easiest way to register is online at scvotes.gov. We want no excuse, in-person early voting, which many, many states have. We're working on a bill in the House on that now. Although it would only provide 10 days, 10 days is a lot better than 1 day. Having everybody appear on 1 day is a vestige of a bygone era. We don't want to eliminate excuses for absentee voting that exist now. And we want persons discharged from prison, and also those who are declared mentally competent after having previously been declared mentally incompetent, told what they need to do to re-register. This is a big issue. A lot of people who have been in prison have been reluctant to vote again. When they haven't, there have been some very unfortunate responses in other states. One man who got out of prison and thought it was legal for him to vote, I believe he was in Texas, but I could be wrong about that, wasn't, and he's been sent to prison for 5 years. I mean, he's getting more time than people who attempted murder in some cases. So we believe there are bills that have been filed to help people know how to get back on the voter registration rolls. And since this is a racial issue, because we know that we have very disproportionate incarceration, that is a really important change to make. And so far, the bills have failed for a number of years. And I hope all of you will help move the state toward a more just and fair approach to election law. As an anthropologist, I know that healthy societies have cross-cutting relationships, so people don't just live in little silos. And our society is very much more siloed now than it used to be in every way, racially and otherwise. Residentially, we don't have a lot of change there. Churches, I mean, you know, notoriously the most segregated hour in America. But the Methodist Church as a whole is a great cross-cutting institution that affects people of both parties, includes people of all sorts of different inclinations and geographic locations in the state, can be very powerful in making people more aware of the need to respect the rights of others on this. I'm going to then talk a little bit about redistricting, which has started in the state, and some of you may find this, I think several editorials in both the Post and Courier and State have started with, I know this topic you think is going to be boring, but you really need to pay attention. Okay, you really do need to pay attention, because if you can vote, it matters if your vote means anything after you vote. In most cases, because of the way we are districted, the way our districts are drawn, in November, when people have voted for a member of the South Carolina House, the South Carolina Senate, or the US House of Representatives, the vote has been essentially meaningless. In the majority of cases, the decision was already made by the primary election. Now, the league is very data-based. We had a professor at Clemson who's on our board, worked with a graduate student to do her thesis, evaluating, is South Carolina horribly biased in a partisan way in the way its districts are drawn? We're not, it's biased, but it isn't horrible. It would not reach the level of Wisconsin or Maryland, the places that have gone to the Supreme Court on this. What we have is incumbent protection. It is the most bipartisan thing that happens at the State House. People actually trade neighborhoods to make it easier for everybody to win re-election. I mean, this has been reported over and over again by people who are actually in the map room, people who are actually legislators. Yes, you know, you'd go to the guy from the next district over and say, I can win up there that's in your district now. You can win here. Let's just trade those. So we have incumbent protection. We have maps posted at our website, again, lwvsc.org, that show just how very non-competitive this state is. Now, it's never going to be a perfect system because, in fact, demography means there are places that are not going to be competitive elections in November. Nobody could draw a competitive district in some places in South Carolina, but it could be a lot better than it is. We're trying to work on that. We hope you will try to work on that. Again, our website has a lot of information on this. There are public hearings going on right now. On Tuesday, the ones that have been scheduled now are for the Senate. On Tuesday, the House subcommittee is meeting for the first time. They will announce what they're planning to do about public hearings. And so if you care about your vote meaning anything, this is a good time to get out there. You know, I'm in Senate District 20, for instance. Now that actually is one of the competitive districts, but it's competitive for an odd reason. It runs all the way up to Irmo. And that, in fact, was designed to protect an incumbent. So there are all sorts of complexities to it. But if you care about this, learn about it, pay attention, and then you can write to the committee. You don't have to show up and testify. You can do it by Zoom, or you can just write to your own legislators and tell them what you believe about this. But redistricting matters immensely. And one of the main things, of course, that it's used for in many cases is racial discrimination. Right now, our congressional districts, if you look at District 6, it's drawn to take in every possible African American. The idea is to keep all those voters in one district and not let them influence outcomes in the adjacent districts. That shouldn't happen. We fully expect that if that sort of thing happens again, and it's very likely to, the ACLU and the NAACP will probably end up in court on it. I hope the league doesn't end up in court. We hate it. We don't have as many lawyers as those folks do. But racial discrimination is a huge factor in how some of these districts are drawn. The idea is called packing and cracking. If you pack voters who are like each other into one district, you make it easier for the other side to win in the adjacent districts. If you crack a community, if you split it in two, you may be able to design districts in which they don't represent a majority in any district and can't elect anybody of their choosing. So this is a primary way to allow people to think they have the right to vote, but to take all the meaning of it away. Participate in the hearings if you can. Write or talk to your legislator. Whoops. And I'm just going to, again, we have a website. So we have tons of information on our website.
Any questions?
You didn't mention anything about real ID. Do y'all have a position on that?
Well, real ID doesn't actually affect election ID. I mean, photo ID is required in South Carolina unless you have a compelling reason not to have photo ID. And I don't think very many people have tried to make that argument. Real ID is simply another version of what's already required.
So I'm just gonna real quick, we do, if some people need to leave, that's fine, but we will ask a few questions right now. I'm gonna moderate between the chat and here. So after you ask a question, I'm gonna repeat it. Otherwise the folks at home won't be able to hear it. So there were hands, but I didn't see who they were. If you want to put them back up again real quick. Heather.
You mentioned the election commission members being nonpartisan. How are they appointed?
Well, actually, the commission itself is nonpartisan. The law requires that at least one of those five be elected from each of the major parties, or designated by each of the major parties. The majority major party is the governor usually, and so he has chosen to interpret that as 4 of his party and 1 of the other party. There was a bill that would have expanded the commission and left room for independents and people, you know, who belong to minority parties. There are a number of minor parties in the state, and the governor's office shut that down very quickly. the subcommittee was told the governor wouldn't sign it. There was no way they'd even consider it.
All right, in the back.
In terms of gathering ballots for those people who might be, say, in a nursing home situation or something, is there any method under consideration for the people who are giving the ballots to someone to verify, to say, I give my permission for this to be delivered by such and such a person?
That's already in place.
So the question, just to repeat it for folks at Zoom, is there a measure for folks in nursing homes to give permission to someone to gather their ballot for them and be able to have the authority to do that?
Yeah, if any, even already, if any third party turns in your ballot, it has to come, it's a form that comes with an absentee ballot. It has to be filled out and designate that person as your person allowed to return your ballot, which is a reasonable precaution.
Does a mail-in ballot require a stamp or is it already prepaid?
Is a mail-in ballot require a stamp or is it already prepaid?
There's nothing in our law that requires that it be prepaid. During the pandemic, the State Election Commission actually guaranteed the postage. And we think that would be a good general measure. Because otherwise it's minor, but it's a poll tax.
All right, we have a question from Zoom. How does SC rank in terms of ballot access for quote unquote minor parties?
Well, I'll have to admit, I don't actually know in detail the process for minor parties to get on the ballot. I know it exists. And there is a bill that would complicate this. There always is, I guess. By prohibiting people from running on more than one party's ballot. Because very often minor parties will, for instance, a Green Party might say, we're going to support the same candidate that one of the major parties, or the Libertarians might say that. And so there is a bill to attempt to prevent that. And that would be a limitation on the ability of these minor parties to participate, because that is a way for them to actually have some influence on the outcome.
Will you speak to the national outside influence of organizations that are coming into the states with model legislation, and how much of that you're seeing in South Carolina?
Tons of it. And
The question is outside of the state, the influence coming in from organizations onto South Carolina voting.
Yeah, in fact, we see places where the bills haven't even been adequately edited before they were filed in South Carolina. One dead giveaway in one was they referred to the Secretary of State's office, which again, he has nothing to do with our elections. So there are all these cookie cutter bills that are intended to prevent people from voting, that are regularly filed here and that do get hearings. And those are the kind of things that we try to prevent.
What happens, as a follow-up question, when you've got individual relationships with legislators and the legislator is filing that bill that's then just handed to them from an outside organization? Do you call them on that? Do they realize it? That seems. Oh
yeah, we call them on it and we discuss it with them, definitely. To function at any state house, you don't want to burn bridges unnecessarily. You recognize that nobody's going to agree with you all the time. And if you want to be effective, you choose your battles. But when we see one of these bills, we fight it, and we do say, we recognize this as something that is a national effort intended to make it more difficult for voters of color. But again, it doesn't necessarily break down by party. I will say we lost one Republican senator who was the best defense against voter suppression bills that South Carolina had, as far as I know. All I had to do was catch him and say, we're worried about blah, blah. And he'd say, don't worry, I'll take care of it. And he did. He was in a position to make it go away forever, never be heard in the Senate. Unfortunately, we lost him. But yeah, we call him on it. But we we stick to the issues. We don't, we don't try not to call people names. We just say, we don't like this bill.
Okay, we have a question from Zoom. Out-of-state college students cannot use their college ID as a photo ID when voting. Do you think this will ever be modified?
There is a bill that we are supporting that has gotten to subcommittee, which is, of course, the big trick. A lot of bills are filed if you get a hearing in the subcommittee. This one has. We are supporting college students being able to use their college IDs. It's part of that bill. We don't know if that's going to get through. Frankly, I wouldn't give it great odds in our General Assembly, but we're going to try. You know, concealed weapon permits are usable. Hunting and fishing licenses. So if you can use those, why on earth can't you use a student ID?
I know our time is running out, but I just wondered, with the districting and the racial inequities of trying to cluster everybody together, does this put a lot of power in the hands of real estate agents? And what, whom they're going to steer toward what areas to buy in?
Well, they've always done that. I think that's just part of the bigger problem of racial discrimination in the state. When I was introduced, it was mentioned that I'm a long-time South Carolina family here, spread all over the place. And one of the things I've discovered through DNA testing is I have mixed race relatives. And one of them turned out to be a senior litigator for the Department of Justice and Civil Rights Division on housing. And it's a complex issue and it's been around for a long time. I don't think there's been a lot of interaction intentionally by the realtors, because what happens is that in drawing the districts, the results of what that has been done is simply taken advantage of to draw lines between races.
All right. Well, thank you so much, Lynn, for coming and answering these questions. We really appreciate all of your insight. I want to invite you all to come back next week for our final meeting in this series. We'll be hearing from Lawrence Nathaniel, the leader of the South Carolina Black Lives Matter movement, who'll be helping us understand what is Black Lives Matter, what isn't it, how does it line up with our faith, and where do we want to get involved with justice for Black people in South Carolina. So thank you so much, everyone.
Thank you.